Judicial Activism and Judicial Overreach. On May 11, 2016, a division bench of the Supreme Court of India, constituting Justice M.B. Lokur and N.V. Raman, came down heavily on both the state governments and the Government of India in respect to their handling of the drought situation in the country. The court went to the extent of instructing the Government of India to form a disaster relief fund to be headed by a judge. On the same day, in Rajya Sabha, the Finance Minister of India argued before the House and tried to make them aware of the efforts by the judiciary to strip them of their power to legislate and decide on policy issues, as setting up of such funds are part of the appropriation of Consolidated Fund of India, which is an exclusive prerogative of the legislative bodies and not of the judiciary. On the 6th of June, the Chief Justice of India, Justice T.S. Thakur, while giving an interview to a private television channel, made some caustic remarks about the legislature and executive. This became further more meaningful, especially due to the recent developments like the striking down of the National Judicial Appointment Commission Bill by the higher judiciary of the country. The issue is significant both from the point of prelims and mains. In case of prelims, try to look into the constitutional provisions dealing with the judicial system in India, especially regarding the powers and jurisdiction of the judiciary both at the union and in the states. As for mains, the topic is important both for General Studies Paper 2 and Essay. What is judicial activism? Judicial activism is use of judicial power to articulate and enforce what is beneficial for the society in general and people at large. Supreme Court, despite its constitutional limitations, has come up with flying colors as a champion of justice in true sense of the word. Justice. This 7-letter word is one of the most debated ones in the entire English dictionary, with the entire world population being linked to it. There is no doubt about the fact that with changing tongues, the definition does change. The judicial activism has touched almost every aspect of life in India to do positive justice, and in the process has gone beyond what is prescribed by law or written in black and white. Only thing judiciary must keep in mind is that while going overboard to do justice to common man, must not overstep the limitations prescribed by the sacrosanct, that is, the Constitution. Judicial activism describes judicial rulings suspected of being based on personal or political considerations rather than on existing law. The question of judicial activism is closely related to constitutional interpretation, statutory construction, and separation of powers. Judicial activism implies going beyond the normal constraints applied to jurists and the Constitution, which gives jurists the right to strike down any legislation or rule against the precedent if it goes against the Constitution. Thus, ruling against majority opinion or judicial precedent is not necessarily judicial activism unless it is active. In the words of Justice J.S. Verma, judicial activism must necessarily mean the active process of implementation of rule of law essential for the preservation of a functional democracy. In a modern democratic setup, judicial activism should be looked upon as a mechanism to curb legislative adventurism and executive tyranny by enforcing constitutional limits. That is, it is only when the legislature and the executive fail in their responsibilities or try to avoid it that judicial activism has a role to play. In other words, judicial activism is to be viewed as a damage control exercise, in which sense it is only a temporary phase. Recent times have seen judiciary play intrusive roles in the areas constitutionally reserved for the other branches of the government. Issues in judicial activism arise when governance is apparently done by mandamus. The Constitution of India operates in happy harmony with the instrumentalities of the executive and legislature, but to be truly great, the judiciary exercising democratic power must enjoy independence of a higher order. But independence could become dangerous and undemocratic unless there is a constitutional discipline with rules of good conduct and accountability. Without these, the robes may prove arrogant. How did judicial activism evolve in India? It is very difficult to trace the origin of judicial activism in India, since the judiciary has come to be recognized as an independent and separate organ of the government under the Government of India Act 1935 and subsequently under the Constitution of India, it would be prudent to scan the period subsequent to 1935 for tracing the origin. However, there are a few instances even prior to that period, where certain selected judges of the High Courts established under the Indian High Courts Act 1861 exhibited certain flashes of judicial activism. Way back in 1893, Justice Mahmood of Allahabad High Court delivered a dissenting judgment which sowed the seed for judicial activism in India. In that case, which dealt with an under trial who could not afford to engage a lawyer, Justice Mahmood held that the precondition of the case being heard would be fulfilled only when somebody speaks. The concept of judicial activism can be seen to be reflecting from the trends exemplified by some decisions and orders of the Supreme Court. They are as under. The judiciary since 1973 claims the power to nullify on substantive grounds even an amendment made to the Constitution by the amending body if it changes the basic structure or framework of the Constitution. This concept of judicial control over the Constitution has been evolved by and known to courts in India only. The undoubted privilege of the legislature, even in respect of their internal proceedings, have been brought under the purview of judicial review. Power of judicial review as exercised by the Supreme Court and High Courts has been recognized by those courts to be an unalterable basic structure of the Constitution. 24 High Courts with the Supreme Court at the apex correct the entire gamut of the country's administration. The concept of state for the purpose of enforcement of fundamental rights has been widened by successive judgments of the Supreme Court so as to include all public, quasi-public authorities. The courts have broadened the scope of locus standi in public interest litigation matters in early 80s. The Supreme Court has often resorted to judicial legislation by virtue of its powers under Article 141 to fill the void created by the so-called legislative vacuum. A thorough analysis of the above list of examples of judicial assertiveness makes it amply clear that it would be very difficult to trace the origin of judicial activism in independent India. A perusal of the catena of decisions rendered by the Indian judiciary after 1950, especially by the Supreme Court, compels anyone to believe that there have been flashes of judicial activism before 1980s. However, there has been no uniformity in all the areas and jurisdictions of the Supreme Court in exercise of a greater judicial power. The amount of activism varied in different areas like interpreting the Constitution, guarding the fundamental rights of the citizens, expansion of scope of locus standi in public interest litigation, omnipresence of judicial review, expansion of horizons of Article 21, and construction of certain directive principles as fundamental rights, and so on. What are the basic reasons for rise and growth of judicial activism? It is very difficult to state precise reasons for the emergence of judicial activism under any constitution. Further, there cannot be any universal acceptance of these reasons to be correct. In view of the conflicting interests and ideologies of various groups of the society concerned with judicial activism in particular and judicial power in general, the following are some of the well-accepted reasons which compel a court or a judge to be active while discharging the judicial functions assigned to them either by a constitution or any other organic law. Number 1. Near collapse of responsible government. When the two political branches of the government, viz. The legislature and executive, fail to discharge their respective functions, there will be a near collapse of responsible government. Since a responsible government is the hallmark of a successful democracy and constitutionalism, its collapse warrants many a drastic and unconventional steps. When the legislature fails to make necessary legislation to suit the changing times, and when the governmental agencies fail miserably to perform their administrative functions sincerely and with integrity, it would lead to erosion of confidence in the constitution and democracy among the citizens. In such an extraordinary scenario, the judiciary may legitimately step into the areas usually earmarked for the legislature and executive. The result is judicial legislation and government by judiciary. Number 2. Pressure on judiciary to step in aid. Now it has become fully established that the judiciary cannot remain a silent spectator when the fundamental or other rights of the citizens are trampled by the government or third parties. The judges, as responsible members of the society, do feel that they have a role to play in ameliorating the worsening conditions of the citizens. As Upendra Bakshi has rightly highlighted, the Indian nation is obsessed with judicial salvation. It has become natural for the citizens to look up to the judiciary to step in their aid and protect their fundamental rights and freedom. This mounts tremendous pressure on the judiciary on the whole to do something for the suffering masses. It may lead to an activist role being taken up by the judiciary. Number 3. Judicial enthusiasm to participate in social reform and change. As has been rightly pointed out, the judges cannot be idle and silent spectators when the times go on changing. As the persons involved in interpreting and applying a law which is not static but dynamic, the judges would like to participate in the social reforms and changes that take place due to the changing times. Under such circumstances, the judiciary has itself claimed to be an active participant in social reformative changes. It has encouraged and at times initiated public interest litigation, also known as social action litigation in India. In such cases, the courts have discarded the traditional constraints on themselves, such as the requirements of standing, rightness of the case and adversarial forms of legislation, and have assumed the function of an investigator, counselor and monitor of administration. This liberalized approach of the judiciary would lead to relaxation of certain procedural and customary rules for invoking a court's jurisdiction, which can be directly related to the expansion of judicial power. So when courts themselves initiate corrective actions for social ills, their activity becomes indistinguishable from that of the commissioners of grievances. Number 4. Legislative vacuum left open. In administrative law, there is a saying that even if the Parliament and all the state legislatures in India made laws for 24 hours a day and 365 days a year, the quantum of law cannot be sufficient to the changing needs of the modern society. The same thing holds well in respect of many a legislation passed by the competent legislature. In spite of the existence of a large quantum of pre- and post-constitutional laws, there may still be certain areas which have not been legislated upon. This may be due to inadvertence, lack of exposure to the issues, the absence of legislation, or indifference of the legislature. Thus, when a competent legislature fails to act legislatively and enact a necessary law to meet the societal needs, the courts often indulge in judicial legislation. In this context, judicial legislation has to be understood as an incident to statutory interpretation. The courts often have acted to fill the void created by the legislature's abdication of legislative responsibility. Number 5. The constitutional scheme. The Indian Constitution contains a number of provisions which give the judiciary enough scope to assert itself and play an active role. Under Article 13, the judiciary is implicitly empowered to review the validity of any law on the touchstone of fundamental rights and to declare the same as void if it contravenes any of the fundamental rights. Under Article 19, the court has power to decide whether the restrictions on fundamental rights are reasonable or not. Under Article 32, any person whose fundamental rights is violated can straight away approach the Supreme Court for the enforcement of those fundamental rights. Further, the right to approach the Supreme Court under Article 32 itself has been made a fundamental right under the caption Right to Constitutional Remedies. Thus, the Supreme Court has been designated as the guardian of the fundamental rights of the citizens, and while playing that role, the Supreme Court often indulges in legitimate judicial legislation and judicial government. Under Article 131 of the Constitution, the Supreme Court has been vested with jurisdiction to uphold the federal principles of the Constitution. Under Article 131 of the Constitution, the Supreme Court has been vested with jurisdiction to uphold the federal principle of the Constitution. The Supreme Court is the highest appellate court and it exercises its appellate jurisdiction in all civil, criminal and constitutional matters. The Supreme Court has been vested with advisory jurisdiction to advise the President on any question of fact or law that may be referred to it. The Supreme Court has rulemaking powers under Article 142 and 145. It has the power to punish any person for its contempt under Article 129. This list is only illustrative and not exhaustive. A cumulative analysis of all the above provisions makes it abundantly clear that the judiciary in India in general and Supreme Court in particular has vast powers under the Constitution and has enough scope for being active and to uphold the cardinal principle of constitutionalism. Number 6. Authority to make final declaration as to validity of law. The Supreme Court of India is the final arbiter and umpire as to the validity of law. Under Article 141, the Supreme Court has the power to declare any law, and the said declaration has the force of an authoritative precedent binding on all the other courts in India, of course except the Supreme Court itself. While adjudicating on the issue of any legal aspect, even though it has to be remembered by the Supreme Court that the Supreme Court judgments are not final because they are infallible, but because they are final. It may be possible that the court also may overlook this principle. In Indira Shani versus Union of India, a 3-judges bench of the Supreme Court encountered a peculiar and belligerent situation where one of its directions in the Mandal Commission judgment to the states to identify the advanced section among the backward classes of citizens, that is creamy layer, for the purpose of excluding them from availing the benefits of reservation, etc. In the instant case, the Kerala State Backward Classes Reservation of Appointments, Posts and Services Act 1995 gave retrospective effect to that. No creamy layer existing in the state of Kerala was found unconstitutional by the court, which took serious note of the action of Kerala government and initiated contempt proceedings against the state. The final authority of the Supreme Court is deciding the validity of law and gives the court a great discretionary power without any accountability whatsoever, and a consequent development is characterized as the judicial activism. Number 7. Role of judiciary as guardian of fundamental rights. The fundamental law of the land, that is the Constitution of India 1950, has designated the higher judiciary in India as the guardian of the fundamental rights of the citizens. A cumulative reading of Article 13, 32 and 226 makes it very clear that the higher judiciary in India has been endowed with the onerous task of upholding the fundamental rights of the citizens. Under Article 13 of the Constitution, any law which abridges fundamental rights shall be declared as void by the Supreme Court and the 24 High Courts. Under Article 32 of the Constitution, the Supreme Court has the power to issue any writ, order or direction to any person or authority violating the fundamental rights of citizens. In fact, the right to approach the Supreme Court itself has been made a fundamental right on its own under Article 32 to 35. Under Article 226 of the Constitution, the High Courts enjoy a power which is even more widely to enforce the fundamental or other rights of the citizens by invoking the jurisdiction of the High Court. All these powers vested in the constitutional courts enable them to exercise vast powers of judicial review in respect of any legislative, quasi-legislative, executive, quasi-judicial or other actions of the state and its agencies. In fact, this is the role which has been played by the Supreme Court and High Courts effectively. The result often is the brooding omnipresence of judicial activism. Number 8. Public confidence in the judiciary. The greatest asset and the strongest weapon in the armory of the judiciary is the confidence it commands and the faith it inspires in the minds of the people in its capacity to do even-handed justice and keep the scales in balance in any dispute. A recent study made by 2 law professors on the role of the Supreme Court of India reveals that 85% of the law students of Delhi University declared that they trust the court rather than the parliament. Majority of the students like the public interest litigation and judicial activism of the Supreme Court. The study shows that there is an extraordinary high level of support for the institutions. Probably in no other country has any segment of the elite public ever demonstrated such overwhelming general esteem for a flagship constitutional court or for any other major institution. This clearly shows the public confidence and trust reposed by the people of India in the Supreme Court as the ultimate guardian of their rights and liberties. The Supreme Court has withstood the test of times through the device of judicial activism. What are the major instances of judicial activism in India? Since the establishment of courts as means of administrative justice, law is made from 2 sources. The prime source is from the legislature and the second is the judge-made law, that is, judicial interpretation of already existing legislation. The Constitution of India already recognizes these 2 models of lawmaking. Article 141 of the Constitution of India lays down that the law as declared by Supreme Court of India establishes the law of the state. It thus codifies what was hitherto an unmodified convention, namely recognition of judge-made law. The process of making law by judges is what can be called judicial activism. Judicial activism, as distinguished from judicial passivism, means an active interpretation of existing legislation by all judges, made with a view to enhance the utility of that legislation for social betterment. Judicial passivism, to put it very loosely and liberally, is interpretation of existing legislation without an attempt to enhance its beneficial aspects. By so interpreting the existing law as top advance and progress, the beneficial extent of that legislation, the phenomena which is now called judicial activism is therefore not one of the recent origin. It originates with the firm establishment of courts as means of administration of justice. For a very long time, Indian judiciary has taken an orthodox approach to the very concept of judicial activism. However, it would be wrong to say that there have been no incidents of judicial activism in India. Some scattered and stray incidents of judicial activism took place from time to time, but they did not come to the limelight as the very concept was unknown to India. However, the history of judicial activism can be traced back to 1893, when Justice Mahmood of Allahabad High Court delivered a dissenting judgment which sowed the seed of activism in India. It was a case of an under trial who could not afford to engage lawyers. So, the question was whether the court could decide his case by merely looking at his papers. Justice Mahmood held that the precondition of the case being heard, as opposed to merely being read, would be fulfilled only when someone speaks. So, he has the widest possible interpretation of the relevant law and laid the foundation stone of judicial activism in India. The Supreme Court of India started off as a technocratic court in 1950s, but slowly started acquiring more power through constitutional interpretations. In fact, the roots of judicial activism are to be seen in the court's early assertions regarding the nature of judicial review. In A.K. Gopalan versus State of Madras, although the Supreme Court conceived its role in a narrow manner, it asserted that its power of judicial review was inherent in the very nature of the written constitution. The constitution appears to be a matter of abundant caution. Even in their absence, if any of the fundamental rights was infringed by any legislative enactment, the court has always the power to declare the enactment to the extent it transgresses the limits invalid. The posture of the Supreme Court as a technocratic court was slowly changed to the activist court. In Sakal Newspapers Private Limited versus Union of India, it was held that a price and page schedule that laid down how much a newspaper could charge for a number of pages was being violative of freedom of pay. The court also conceived a doctrine of giving preferred position to freedom of speech and expression, which includes freedom of pace over the freedom to do business. The Supreme Court held that as a newspaper was not only a business, it was a vehicle of thought and information and therefore could not be regulated like any other business. In Balaji versus State of Mysore, the Supreme Court held that while the backward classes were entitled to protective discrimination, such protective discrimination should not negate the right to equality and equal protection of law. It held that backwardness should not be determined by caste alone, but by secular criteria, though caste could be one of them, and that the reserved seats in an educational institution should not exceed 50% of the total number of seats. Chitralekha versus State of Mysore, similar restrictions were imposed on the reservation of jobs in civil services. These are examples of judicial activism of the early 1960s. In these early years of the Indian Supreme Court, the inconvenient decisions of the Supreme Court were overcome through the device of constitutional amendments. The first, the fourth and the seventh constitutional amendments removed various property legislations from the purview of judicial review. Therefore, a debate on the scope of Parliament's power to amend the constitution started. A question was raised before the court in 1951 in Shankari Prasad versus Union of India whether the Parliament could use its constituent power under Article 368 so as to take away or abridge a fundamental right. The court unanimously held that the constituent power was not subjected to any restriction. That question was again raised in Sajjan Singh versus State of Rajasthan, and this time two judges responded favorably, though there was a minority view. In 1967, L.C. Gulathan versus State of Punjab, that minority view became the majority view. By a majority of 6 against 5, it was held that Parliament could not amend Constitution so as to take away or abridge the fundamental rights. Thus, apart from exercising power of judicial review in an expansive manner, to assert itself more in the interest of constitutionalism, the Indian Supreme Court has exercised even more and wider powers. The court exercises the power to do anything or to give any direction to render complete justice. The court has assumed to itself the power to determine the validity of even a constitutional amendment affected under the Article 368 in the aftermath of Keshavananda Bharti versus State of Kerala. Probably no court in the world under any form of constitutional government exercises such power. This can be cited as the best example of judicial activism in India. The Supreme Court has broadened the scope of locus standi in the matter of enforcement of fundamental rights of the citizens by ushering in a new era of public interest litigation, starting with the early 80s. The credit for this welcome development goes to a few individual judges of the Supreme Court like Justice P.N. Bhagwati, Justice V.R. Krishna Iyer, and Justice Kuldeep Singh in recent times. However, over the years, the social action dimension of PIL has been diluted and eclipsed by another type of public cause litigation in courts. In this type of litigation, the court's intervention is not sought for enforcing the rights of disadvantaged or poor sections of the society, but simply for correcting the actions or omissions of the executive or public officials or departments of the government or public bodies. Examples of this type of intervention by the court are innumerable. In the interest of preventing pollution, the Supreme Court ordered control over automobile emissions, air and noise, and traffic pollution, gave orders for parking charges, wearing of helmets in cities, cleanliness in housing colonies, disposal of garbage, control of traffic in New Delhi, made compulsory the wearing of seat belts, ordered action plans to control and prevent the monkey menace in cities and towns, ordered measures to prevent accidents at unmanned railway level crossings, prevent ragging of college freshmen, for collection and storage of blood banks, and for control of loudspeakers and banning of firecrackers. Which are the instances argued as judicial overreach in India? In recent orders, the Supreme Court has directed the most complex engineering of interlinking rivers in India. The court has passed orders banning the pasting of black films on automobile windows. On its own, the court has taken notice of Baba Ramdev being forcibly evicted from the Ramlila ground by the Delhi administration and censored it. The court has ordered the exclusion of tourists in the core area of tiger reserves. All these managerial exercises by the court are hung on dubious jurisdictional peg of enforcing fundamental rights under Article 32 of the Constitution. In reality, no fundamental right, individuals or any legal issue are at all involved in such cases. The court is only moved for better governance and administration, which does not involve the exercise of any proper judicial function. In its most activist and controversial interpretation of the Constitution, the Supreme Court took away the constitutionally conferred power of the President of India to appoint judges after consultation with the Chief Justice and appropriated this power in the Chief Justice of India and a collegium of 4 judges. In no constitution in the world is the power to select and appoint judges conferred on the judges themselves. The court is made the monitor of the conduct of investigating and prosecution agencies who are perceived to have failed or neglected to investigate and prosecute ministers, officials of the government. Cases of this type, such as investigation and prosecution of ministers and officials, believed to be involved in Jain Hawala case, the Fodder scam involving the former Chief Minister of Bihar, Mr. Lalu Prasad Yadav, the Taj Corridor case involving the former Chief Minister of Uttar Pradesh, Ms. Mayawati, and the recent prosecution of the Telecom Minister and officials in the 2G telecom scam case by the Supreme Court. The Supreme Court has made an order even in a military operation. In 1993, the court issued orders on the conduct of military operations in Hazratbal, Kashmir, where military had, as a matter of strategy, restricted the food supplies to hostages. The court ordered that the provision of food of 1200 calorific value should be supplied to hostages. Commenting on this, an Army General wrote, "For the first time in history, a court of law was asked to pronounce judgment on the conduct of an ongoing military operation. Its verdict materially affected the course of operation. Even proceedings of legislature are controlled by the court." In the latest case of Uttarakhand Assembly, the Supreme Court ordered the Assembly to conduct a motion of confidence and ordered the Speaker to conduct proceedings according to a prescribed agenda and not to entertain any other business. Its proceedings were ordered to be recorded. These orders were made in spite of Article 212 of the Constitution, which states that courts are not to inquire into any proceedings of the legislature. Matters of policy of government are subject to the court's scrutiny. Distribution of food grains to persons below poverty line was monitored, which even made the Prime Minister remind the court that it was interfering with the complex food distribution policies of the government. In the 2G licenses case, the court held that all public resources and assets are a matter of public trust and they can only be disposed of in a transparent manner by a public auction to the highest bidder. This has led to the President making a reference to the court for the court's legal advice under Article 143 of the Constitution. In the same case, the court set aside the expert opinion of the Telecom Regulatory Authority of India to sell 2G spectrum without auction to create greater teledensity in India. The court has, for all practical purposes, disregarded the separation of powers under the Constitution and assumed a general supervisory function over other branches of the government. The temptation to rush to the Supreme Court and 24 High Courts for any grievance against a public authority has also deflected the primary responsibility of citizens themselves in a respective self-government of making the legislature and the executive responsible for their actions. The answer often given by the judiciary to this type of overreach is that it is compelled to take upon this task as the other branches of government have failed in their obligations. On this specious justification, the political branches of the government may, by the same logic, take other functions of the judiciary when it has failed. And there can be no doubt that there are many areas where the judiciary has failed to meet the expectation of the public by its inefficiency and areas of cases. Criticism. According to some critics, judicial overreach is upsetting the constitutional balance among the three organs of state: the legislature, the executive, and the judiciary. The idea of judicial activism, when it emerged in the public realm some decades ago, gained currency and some active acceptance because it was considered necessary to correct the failings of legislature and the misdeeds of the executive. But it has now grown into a situation where the idea of separation of powers, which should be considered a feature of the basic structure of the Constitution, is challenged. Activism can deteriorate into overreach if the judiciary considers itself the sole custodian of public interest, interprets public interest in its own fashion, and seeks to force the legislature and the executive to implement its version of it. Strictly, it is not its remit to define public interest. It has only got to interpret the laws and decide whether they conform to the Constitution. There is a thin line between activism and overreach. While judicial activism is considered positive to supplement the failings of the executive, but the overreach into the executive's domain is considered an intrusion into the proper functioning of democracy. According to some experts, judicial overreach gnaws at the very root of democratic structure, precariously hanging on the principle of separation of power. Just as independence of the judiciary is part of basic structure, the primacy of the legislature in policy making is also part of the basic structure, and interference by the courts into their domain is not justified. In the end, I would request you to look into the PDF provided below to get an idea about the possible questions on this issue. The questions provided are only samples. There can be other types of questions as well on this issue. Thank you.